session where I would like to invite upon the stage the chief guest of our event, the Honorable Mr. Tushar Mehta, Solicitor General of India, for a brief inaugural address. Shri Tushar Mehta serves as the Solicitor General of India, a prominent legal position appointed by the government. With a distinguished career in law, he has played a pivotal role in representing the government's interest in various legal matters. Known for his expertise and advocacy skills, Mr. Mehta has contributed significantly to the legal landscape of India. Also, I would like my directors to please come upon stage and welcome our chief guest, the Honorable Mr. Tushar Mehta.
Mr. Tushar Mehta, you see, he's, if one can say with some certainty, he's the outstanding lawyer of the decade. Outstanding lawyer of the decade. During the last 10 years or so, he has been the face, you see, of government, representing the government of India, which has brought in new policies, new programs, which are of course challenged in the courts, but he has successfully defended, you see, everything which stands for Atmanirbhar Viksit Bharat. A big applause for Honorable Tushar.
Dr. Lalit Bhasin, a father figure for all of us, Abhishek Gaurav, and all luminaries. Good morning to all of you. There are rare occasions where such brilliant minds who are not in the legal profession in the sense of court work, but who are in the legal profession who virtually guide and push those who are in the court work are under one roof. At least I am attending this kind of a function for the first time. I genuinely compliment the organizers. All of you are brilliant minds. I am aware, having appeared for some of the companies, that you are the mind behind the existence and sometimes survival of the company. Friends, the business and regulatory environment in India is becoming increasingly complex and at the same time increasingly simple. The motto of the Prime Minister of less government and more governance has made the whole thing very simple. And you must be experiencing that. Less lack of, or at least less red tapeism, political interference at political level, at departmental level, etc., have, I'm told, substantially reduced, because I'm not in the business, nor do I have to deal with that part of the governmental business. But India is developing very fast. India is one of the fastest growing economy in the world. In terms of digital India, we are surpassing virtually every developed country in the world. Virtually every developed country in the world. We are adding one mobile user with internet, 3 mobile users with internet every second. That is the position in which the country is right now surviving, country is now, right now progressing, and country is soon to become one of the fastest growing economies in the world. And there, your role as kind of guiding force behind big companies become very, very crucial and pivotal. The subject is interconnections and interdependence between in-house counsels and external counsels. The subject is very well chosen. It is, you are internal counsels, you are general counsels, and we are external counsels. There is no difference between the two of us except a wall of the company dividing the two of us. We are doing something in the court as guided by you from within the company's precincts. Both these entities will have to collaborate more frequently, and tactical and strategic issues will have to be discussed, as opposed to the trend in India when interactions were limited to litigation or complex merger and acquisition deals. Friends, this type of associations, this type of engagements, this type of debate, discussions, in a collective form is rare. A company has a problem, the company engages an individual counsel, and there is a debate and discussion about that particular matter between that particular general counsel and that particular lawyer who will be appearing. But can we not, as a policy, have such gatherings more and more where you can tell us the problems which you face from us, and we are problem makers, I'm admitting that, and the issues which concern us so far as your interaction with us are concerned, you are generally not problem makers. The blame is more on this side than on that side. The external law firms enable in-house counsels to lower overhead costs by hiring highly specialized, on-demand, skilled external attorneys without compromising on the quality. That is the second issue which is highlighted and which is going to be highlighted in this 2 days of illuminating debate. But I have one thought which I will just plant in your minds, and if time permits and if the program permits, you can dwell upon that. There has to be a coordination between in-house counsel and external counsel, no doubt about it. But all of you are qualified legal practitioners having chosen to represent only one client. We are qualified legal professionals having chosen to represent whoever engages us, except that there is no difference. Can you not debate and discuss representing your own company in some of the matters and excluding this external part? What you know about your facts, what you know about the problems faced by the company, what you know about the solutions which are possible within the frameworks of law, the lawyer appearing would normally not be able to represent. Why confine your intellect, your experience, and your knowledge of the subject, sometimes domain expertise, to merely briefing an external counsel? You can, in some cases, represent the company yourself. I'm not sure whether there is any debate which has taken place on these lines, and whether any one of you. No, I'm sorry. The Bar Council does not prohibit the party in person to appear. I can represent my company. Even if I am not a lawyer, I can represent my company. Bar Council prohibits a private party representing the company. But if you are an authorized representative of the company, you can definitely represent your company in the court of law. I am saying something at the cost of our professional interest. In addition to knowing the business needs of the company, it is more important to undertake how the in-house lawyers like things to be done, and the best way of finding out, this is for us, how we are supposed to be doing it. Finding out this point is to ask him. An in-house lawyer is unlikely to want a full written legal opinion on every point of law, particularly if he is then charged for it, and may prefer an informal email or phone call. However, there may be times when an in-house lawyer does want formal memorandum that can be passed on to the management. Finding out what the in-house counsel wants is essential. Misunderstanding at this stage can severely damage relationships and waste of time. It is important to clarify that these preferences at the beginning of any matter, external lawyers should be wary of feeling as if their role is merely to give legal advice, as this can be received as patronizing. When you go to an external lawyer, you must make it clear that you are not just being briefed professionally to give a particular opinion the way the company would like you to give, but you are kind of a guide. And please tell us what the real legal position is. We will discuss it with the company informally, and if the company doesn't find the advice to be commercially suitable, then don't take the legal opinion in writing. I'm sure all of you must be doing that. At least in my experience, most of the company in public sector does it. All of you must be representing the big corporate clients, etc. But in public sector enterprises, what they do is they come, they seek advice, they discuss with the management, and if the management feels that the advice which is given, which is honest advice as per our understanding or lack of it, whatever way you look at it, then they say they don't give your written opinion because that may not be commercially viable to follow that advice. As a policy, and of course, taking the company in confidence, taking the management in confidence, you can perhaps, if you are not doing it, proceed with this kind of an internal discussion more as a guide rather than as an external professional. A good relationship between in-house counsel and external lawyers also require practical thinking. The external lawyer needs to follow instructions carefully, respond in good time, and make advice focused and user-friendly. For example, by summarizing questions first and then going into the more details. This is where the problem arises. Generally, I have seen what happens is, unless some of us who are known for giving tailored opinions as per the wish and desire and needs of the clients, the rest of us, we give legal opinion on the basis of the propositions of law which are presented before us. What will be the interpretation? What can be the fallout? What was the intention of the legislature? How the court would ultimately view a particular difficulty? And then leave it to the company to decide what steps to be taken. There are two reasons. A, most of the times it is not possible for the external counsel to micromanage how the company is going to implement his opinion or advice. It is essentially for the company to do it. Many a times, we, the external counsels, do not wish to take that responsibility of running the company. We only say that this is the law, now you take your own call. You are entitled to, and it is advisable for you to insist that don't give the legal opinion only. Give us in writing the way forward for the company. Mere answering legal proposition is no legal opinion. Unless, in fact, circumstances of a particular case, that's the only thing which an external lawyer can do. But I would suggest to all of you to insist that just not stop at giving the legal answer. Give us the way forward. What are the requirements? What resolutions are to be filed? What compliances are to be made? Which authorities are to be contacted? And what is to be done? There would be some things which a lawyer will not be able to tell you. How to persuade the bureaucrats, etc., etc. That depends upon your experience or experience of what now they call liaison officers. That they will do. But whatever is to be legally done on the administrative side of the company, you must insist that the lawyer gives you that. The external lawyer gives you that. Friends, we are literally and figuratively two sides of the same coin. the external lawyer exists because the company exists, and the company exists because they are in your safe hands. Please ensure that your company never feels that the company is not in safe hands. I can tell you from my interactions with some of the leading industrialists, they always say that there are two categories of in-house counsels. A, the first category, those who tell us what we want to hear. And two, those who tell us what the company should hear. They always trust and respect the second category, whether they show it or not, and try to be in the second category. And this is what eminent industrialists have told me. When in a friendly way, I don't appear for any of the private companies, obviously because of the position I'm holding, but in friendly terms, when we discuss that how do you manage your legal affairs, everyone in different words but have said this, that we have two categories of people, those who want us to be pleased and those who want us to be guided. And we always rely upon the second. It's very easy to fall into the bracket of the first, but it's not a long-lasting relationship with the company. The second one is always trusted, and the trusted relationship always lasts longer, and progress is made only in that route, not in route number one. Friends, I wish I would have been able to participate in both the days and learn from you, because what is your perception? I'm sure you will be sharing amongst you the problems which we create and you face, and those problems need to be addressed. If I would have been here, I would have welcomed those problems which we create, sometimes just to show that we are very great, eminent lawyers, and sometimes out of sheer nature. Some people are fighting fit by nature, and some people want to show that they are great people. Whatever are your problems, but let this not be an end by itself. This seminar must result into something concrete. Whatever are the discussions must be recorded somewhere in whichever form it is possible, and it should go to the external councils without naming anyone, that this was the general consensus, that these are the problems which we are facing when we deal with you. And those who are interested in the long-lasting relationship, those who are interested in ensuring that your trust in me, I'm saying in a representative capacity, is maintained, they would mold their ways, they can mold their ways, or at least they should mold their ways. I wish this function a great success. Let this not be an end by itself, but a beginning. Please write it down, the conclusions arrived at, or at least the issues flagged, and inform every external counsel which you might be going to, including me. You might not be coming to me, you will not come to me, because I don't represent private companies, I cannot represent private companies, but I should also like to know, I would like to know, what are the problems which we on external side create, sometimes knowingly, sometimes unknowingly. Friends, I am not taking trouble, giving you trouble of listening to a long speech. I am really thankful to Dr. Bhasin and Abhinav that I am given this opportunity to be amongst one of the most brilliant minds of the country and abroad. I thank them, and I wish all of you a very brainstorming and satisfying 2-day seminar. Thank you so much.